Supreme Court has ruled on President Trump's tariff policy. Definitely not a win for President Trump, though it is a little unclear all of the little nuances that come out of the Supreme Court.
So we got the opinion this morning from the court, and the short version of what they found is this. Comes from the opinion from Chief Justice Roberts. Fulfilling our role, we hold that the IEEPA, which is International Emergency Economic Powers Act, does not authorize the president to impose tariffs, therefore overturning and upholding a appeals court judgment which blocked the use of tariffs under this statute. But it's a lot more complicated than that. So top line is that they overturned the use of the tariffs under this Emergency Economic Powers Act. But what does it mean in reality? Well, there's a lot of that we'll get ahead to. But once again, this is one of those opinions that we've spent all morning kind of looking at, consulting with the attorneys at the ACLJ, getting a readout on. But just listen to this, because this is how convoluted sometimes these opinions come down. Chief Justice Roberts announced the judgment of the court and delivered the opinion of the court with respects to parts 1, 2A1, and 2B, in which Sotomayor, Kagan, Gorsuch, Barrett, and Jackson joined, and an opinion with respect to parts 2, A2, and 3, in which Gorsuch, Barrett joined. Gorsuch and Barrett filed concurring opinions. Kagan filed an opinion concurring in part and concurring with the judgment. Sotomayor and Jackson joined. Jackson filed an opinion concurring in part, concurring with judgment. Justice Thomas filed dissenting opinion. Kavanaugh filed dissenting opinion, in which Thomas and Alito joined. So a lot of opinions out there, a lot of dissents out there. We'll break it all down for you. But once again, sometimes these very nuanced questions of law come down in a very convoluted way when it comes to the Supreme Court based off of ideologies, the way that the law is read, and we'll get into all that to explain it so hopefully you can understand better what this actually means.
And what this does, Maheen, at least it gives you, if you want to look for a positive spin, it gives you a talking point to maybe some of your more liberal friends and neighbors when they go, Supreme Court is overrun by Trump supporters who only will do what President Trump has to say. Well, clearly not.
Really, there's a tale of two opinions here, the way I see it. And one is the opinion of the court. That is the Chief Justice that authored that and has the majority in parts and on the judgment. So at the end of the day, sometimes you get a concurring opinion on some of it, but not all of it. So the real opinion of the court is only part of what the author wrote. This, they also concur in the judgment. So at the end of the day, even the liberal members said, hey, we agree, let's overturn the tariffs, even if we don't agree with all of your rationale for why. But what this all stems from is the president used the Emergency Powers Act, the International Emergency Economic Powers Act, IEPA is what it's called for short, and he declared early in his term a national emergency both on drug trafficking, and that's how he handled a lot of the tariffs with the southern border and other countries that may enable trafficking in some ways, as well as the trade deficit emergency. And that is where the vast majority of the global tariffs landed. And this suit that was brought against the administration was from a company that was saying that they were being harmed by it. It's Learning Resources Incorporated et al. There were other members that joined on with that, but they were the head of the plaintiffs here. And they were bringing it against the United States to try and overturn these, saying it's harming their business and that it was beyond the president's scope of power. And the court agreed with them to a degree, saying that the fact that this law, IEPA, has the words regulate and importation does not give the authority to levy tariffs or duties. And I'll read from page 5. It says, based on the two words separated by 16 others in section 1702A1 whatever of IEPA, regulate and importation, the president asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words cannot bear such weight. So they are saying that this broad interpretation of IEPA does not grant the authority for the president to use what they describe as, and is correct, a tax, that the power to impose tariffs, this is also from the opinion, is very clearly a branch of the taxing power. They cite Gibbons v. Ogden, and they say a tariff, after all, is a tax levied on imported goods and services. And they continue to go on until they give their final judgment that we claim no special competence in matters of economics or foreign affairs. We claim only, as we must, the limited role assigned to us by Article 3 of the Constitution. Fulfilling that role, we hold IEPA does not authorize the president to impose tariffs. So all that to say,
I'm breathing.
The opinion says that tariffs are a tax, and that the Congress, when in giving this law, IEPA, did not specifically grant the power to the president to use the taxing power through tariffs. And because of that, it is Congress's role only to levy taxes. Therefore, because it doesn't explicitly say it, this broad interpretation will not stand, and we overturn the tariffs.
We got a lot of calls coming in. A lot of them are very similar, I'll be honest. So we're going to kind of try to sort through these. Now, Cliff's an ACLJ champion, so Cliff gets to go first. Cliff's calling from Illinois. Cliff, go ahead.
Listen, if you take a tool out of the president, the executive branch, if he doesn't have emergency powers to deal with unreasonable nations, whoever they may be, through tariffs, what would be his only decision to go after ones that are being unreasonable with us? Either you go to my winds or I'm going to bomb you to oblivion.
Cliff, that is part of the problem that Justice Kavanaugh saw with this ruling. Yeah. And I want to bring that up as well, because the court, once again, is also only talking about peacetime. This emergency, International Emergency Economic Powers Act, is dealing with emergencies that the president declared, but not necessarily wartime tariffs.
That's why it gets so
there are
petty.
Other laws that deal with that, because we are not at war with every country in the world, and these were global tariffs. But here is the concern, Cliff, that Justice Kavanaugh brought. One is that he says in his dissent, the sole legal question here is whether under IEPA, tariffs are means to, quote, regulate importation. The statutory text, history, and precedent demonstrate the answer is clearly yes. Like quotas and embargoes, tariffs are traditional and common tool to regulate importation. And he goes on to even draw the analogy, of which the chief pushed back and did not agree with, but that the predecessor to this law was Trading with the Enemy Act. And in 1971, President Nixon imposed a 10% tariff on almost all foreign imports. So the president, using the predecessor to this law, Richard Nixon, did basically a blanket tariff of 10%. That was upheld by the Supreme Court in the 70s. Now, this is a new law that kind of replaced that Trading with the Enemy Act, which had different language, but kind of kept the same core language when it came to this. That's where Justice Kavanaugh is saying, look, Congress didn't specifically then ban the tariff portion, of which was upheld by this court. And then he also goes on to say, this is going to create a mess, by the way, because there's a bunch of other statutes that allow the president to impose tariffs.
Right.
So he goes on to say, and I think this is a fascinating statement, is that he says, basically, in essence, the court today concludes that the president checked the wrong statutory box by relying on IEPA rather than another statute to impose tariffs. So the court didn't even say the president can never impose tariffs.
They just said maybe he filed it incorrectly.
Exactly, that maybe using IEPA, which was a quicker way to do it than some of these other statutes, that they're just saying under IEPA, no tariffs. Justice Kavanaugh had a big problem with that.
He brought the wrong document to the DMV, trying to get that real ID, and that's what happens, okay? You know, it sometimes takes you a few times to go back.
Well, don't say that. That may make people think, oh, maybe the SAVE Act's not a good idea.
Yeah, I don't know.
Go back a few times.
That's true. There are a lot of comments coming in asking specifically about, okay, what does it mean for the tariffs right now? Like, as of today, are they done? Do they not exist? Where are we now with those tariffs? Including, by the way, some of you who are in small business who have maybe had some concerns with the tariffs.
That's right. And I think
maybe you're looking at a little relief here.
As of this, that the tariffs that were imposed under IEPA the lower court has upheld that blocked them. So therefore, they are going to no longer be in effect.
Yeah, and in theory, that would be.
But here's another problem.
Immediately?
Here's another problem. So the government's no longer going to be collecting the tariffs, but they've collected billions of dollars of tariffs. One thing the court didn't address, and it is remanded back to a lower court, so maybe we will see something out of a lower court of how to address this. But the Supreme Court didn't address how to handle the money that they're now saying was collected improperly.
Don't give me any ideas.
Which are billions of dollars. And even Kavanaugh points to that, saying that this is going to be a situation because we don't even say how. It says the refund process is likely to be a mess. And how is that going to play out at this point? We don't know at this stage of the game.